Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk about guardianship as it relates to probate. Okay. Unfortunately, there are incidences where either both parent dies or one parent dies and the other is unable to care for the child, or the child is abandoned, or both parents are living but for whatever reason, the probate court assigns a guardian. Now, for your information, there are basically guardians of two different types regarding in probate court. One is guardianship of the person, and the other is guardianship of the estate itself. So the guardianship of the person, which will, and actually both of these usually last until the child turns 18 or becomes emancipated or marries or dies. Okay. But generally speaking, the guardianship, whether it is of the person or of the state, is a fiduciary responsibility, which means that the guardian has a right which is under probate law, which must follow high and strict standards to make sure that either the person, which is the child, is properly taken care of, or the estate is properly managed. So when we're talking about guardianship of the person, of course, that will involve pretty much everything that is normal for a guardian. They have to make sure that the child is properly dressed, has food, clothing, shelter, has proper medical care, has proper education, and basically is taken care of. Okay, that would be the guardianship over the person. And again, unless there is some issue as to why it should not continue until the child's 18, it will continue automatically unless it's terminated. And normally, guardianship over the person cannot and will not continue over the age of 18, since the child then will be considered an adult and will have to essentially fall under the necessary laws as being an adult. Now, guardianship over the estate is a different matter. It is somebody who is taking care of all of the funds and the property and so forth, and the blocked accounts, essentially, where the child can't get into it until the child's 18. So, it's making sure if it's a house or apartment complex or real property, that it is properly being taken care of, that it is maintained, that the taxes are paid, the mortgage is paid, that it's properly rented out, that it's on the market, that it's not going below value and so forth, that the funds, depending how much and how many much funds there is, that it is being invested wisely, that it's not being, thrown into international, high risk funds and so forth, that basically it will remain as it is, plus a normal growth of investment until the child's 18. And then, of course, there are payments that would go to the guardian for performing these duties. And, of course, those payments have to be reasonable. They can't take half the estate just to do this. Generally, there's an agreement among the parents and the guardian, if anything happens to them, that the guardianship, that they agree to be a guardian. And then, of course, the probate court will order the guardianship. Keep in mind that the probate court retains jurisdiction over the child and over the property until the child turns 18 and or the guardianship is terminated. So if you like the video, click like, subscribe. Feel free to give my office a call. I'll give a free consultation, let you know what can be done, what can't be done, and what the costs are. Okay, more on the coming videos.